Thank you for joining us today for our webinar. This is actually our final webinar in a patient data licensing webinar series. My name is Kirsten Loita. I'm a partner at Osage University Partners, leading our university relations efforts. Today, I'm so pleased to have 5 of our previous panelists in the series joining us again. Throughout this webinar series, we've attempted to cover the most pressing questions arising at academic institutions that are associated with licensing patient data. Today, we will review some of those areas. What is the data, what you can do with the data, and how you can license the data. We'll also have an overview of GDPR and answer remaining questions that may have fallen outside of these topics or that you may have still on these particular topics. We'll go ahead to the next slide and introduce our many panelists today. Angie, do you want to start us off, and then I'll call on each of you to do a brief introduction of yourselves.
Sure. Hi, I'm Angie Kuyak from the Broad Institute. I'm head of legal for the tech transfer and licensing operations.
Great. David?
Yes, I'm David Peliquin, a partner in the Boston office of Ropes & Gray, where I practice in the firm's healthcare group.
Great. Nick?
Hi, I'm Nick Brzezowskis. I'm the technical director of the Human Imaging Research Office at the University of Chicago.
Thanks, Nick. John?
I'm John Plummer. I lead the contracts management unit within the Office of Sponsored Programs at Vanderbilt University Medical Center in Nashville.
Terrific. And Steve?
I'm Steve Gardner. I'm a patent attorney at the law firm Quarles. I'm based in our Madison office, and I lead our industry team focused on research institutions and higher education.
Great. Thank you so much, Angie, David, Nick, John, and Steve. And thanks for joining us again for a second installment in this series to answer these remaining questions. We really appreciate the additional time that you're devoting to this. We'll go to the next slide. For those of you who are joining us for this series for the first time, this shows the other webinars that occurred previously in this particular series. We want to thank all of the universities and medical centers, as well as the 2 law firms, Ropes & Gray and Quarles, who helped with this webinar series. Really appreciate not just the time that you've put into this, but the experience, the background work that went into it as well. Really, we've received so many compliments about this webinar series and how useful it has been for academic institutions, as well as startups in these particular areas. We'll go to the next slide. You can find all of these webinars on OUP's partner portal, and a recording will also be publicly available via our YouTube channel. The partner portal is an online portal for the tech transfer officers and researchers at our partner universities that's full of relevant tech transfer content, as well as startup content. And this slide shows directions on how to download this particular webinar. Also, all of the people who registered for this webinar, so all of you attending today, will receive a link to this webinar, as well as copies of the slides afterwards, okay? And if you are going on to YouTube, you can just search for Osage University Partners, and that'll pull up all of our webinars that we've ever given and put up on that particular channel. We do encourage questions throughout this webinar, especially this webinar, since this is a webinar that is really about you and the remaining questions that you have on this particular subject. So please use the Q&A tool in the Zoom toolbar down there, usually at the bottom, to submit your questions. And please do not use the chat. That's much harder for us to track. I'll review those questions as they come in and ask them as appropriate to one of our five panelists. We did receive a number of questions beforehand, which we've incorporated to our prepared materials, as well as Q&A for today. We do have other webinars that may be of interest that are coming up, including a webinar on the Nucleate and Activate programs at the end of September. In October, our popular annual Ask a VC webinar will be back as well. We recently sent out registration materials for these particular webinars, and you can also find the information for them on our LinkedIn account. So next slide. A short intro on OUP for those of you who don't know us. We're a venture capital fund that partners with academic institutions to invest in their startups, typically by exercising participation rights available through their licenses. As a part of this partnership, the institution shares in our profits and receives programmatic support on tech transfer and academic startups, such as these types of programs. We're now on our 4th fund, and we've made investments in over 130 different companies in all areas of deep sciences. We can go to the next slide just to show the types of technologies, or startups, I should say, that we've invested in. If you ever have any questions about our model, feel free to reach out to me or anyone else on our team. So we'll go to the next slide. This is just a reminder of what our agenda is today. We're going to go do summaries of the previous first 3 webinars. Again, the what is the data, what can you do with the data, and how you can license the data. Then we'll do a few slides. David's going to do a few slides on GDPR, and then we'll go to the Q&A section. So with that, I will pass it off to Nick to do the summary for the first webinar. What is the data? So we'll go to the next slide.
Hi, thanks. So yeah, you can just jump ahead to the next slide. I'll talk about what we did in part 1, which is what was the data. So we talked about broadly the sources where you would find the data, or what we call the data origin. So that could be data generated during routine clinical care, could be data that came about during clinical trials or other types of research studies, or it could be data that was generated, say, within a research lab. So all of those we consider to be different places where you could find all sorts of data, healthcare-related data for your research projects. Next, we talked about the types of data that you might be interested in getting. So that would include things like narratives or text, like patient histories or surgical notes, things of that nature. Also included like numeric values, results of tests, and other types of structured data. And then all sort of more sophisticated types of data like medical images or scanned documents and things of that nature. And then finally, when we also talked about data sources, which would basically be where are these types of data stored and where would you need to extract them from. So very broadly, that included systems like electronic medical record systems or billing systems, other types of specialty information systems like radiology PACSs or laboratory information systems. And then an increasing number of academic medical centers may also have groups called research data warehouses or clinical research warehouses, where already curated forms of these types of data may exist specifically for use with research purposes. And then finally, David talked about a number of different legal considerations that surround the use of all of these types of data. That included HIPAA, which I'm sure we're all familiar with at this point, and also different types of de-identification, including safe harbor and limited data set data. Federal rules like the Common Rule, various types of state laws, data provenance and ownership, and also we touched a little bit on international issues, which I know David's going to talk more in length about today. And then as a quick follow-up, as it turns out on my end of things, very shortly after the first part of the seminar was given, the University of Chicago actually published the paper noted here, where we go into a little bit more depth on the principles that University of Chicago actually uses when determining whether or not to share or make biomedical data available for secondary use. So I've included that link here for those who are interested. Be happy to talk more about it later as well.
Great. And we'll work actually on putting that link in the chat as well so that people can open it directly in just a minute here. Great. Thank you so much for that review, Nick. We'll go on next to John.
Hi. So our second webinar was what can we do with the data? My co-presenter, Gavin, who wasn't able to be with us today from Duke, and myself both work for research contracting offices at our respective institutions. So that somewhat colored the perspective that we took. We started by looking at how we vet a request for a data transfer that comes in from an investigator. How do we determine what that's going to be? Research agreement, data use agreement, various different types of instruments. Can we do it looking at IRB issues, informed consent issues, what applicable laws and regulations allow? We looked at the landscape of institutional policies using our universities as examples. How do we make a risk assessment? How do we determine if a data transfer is something that Duke wants to do or Vanderbilt wants to do? And then we spent some time going through appropriate contract terms that we would to facilitate the desired transfer on the part of the investigator and to protect the interest of the institution. So that's sort of what we covered in webinar 2.
Great. Thank you, John. And then we'll move on to Steve for the summary of a webinar 3.
Well, Angie Kuyak and I presented, and a lot of what we went through were some hypotheticals, but I sort of tried to distill the main points here. We started by talking about implications of IP policies, and sort of surprisingly, there's a lot of variation among research institution IP policies in terms of what they say about data. They'll talk about inventions, all of them do, but what they say about data could be silence. It could account for someone having generated data and it gets assigned to the institution, or sometimes there are some that even say faculty members retain copyrights and data themselves. Another issue that came up was whether these policies actually account for a revenue share to data contributors or just inventors. So the Bayh-Dole Act talks about sharing revenue with inventors for academic institutions, but not data or copyright. So you don't have to do that. But we thought it would be helpful if you're going to do it to think about having a policy or even some guidelines in place so you don't start negotiating with faculty members who felt left out. Angie had a great graphic that talked about assessing the value of data. And feel free to chime in, Angie, but she sort of looked at some of the attributes of the data, like whether it's, exclusive to the university, if there are available alternatives, and what would be the cost to recreate those. Would there be some reliability or repeatability concerns if the data were to be, recreated elsewhere? And there are some time to market advantages to having data from the university. So licensees like to talk about the fact that data doesn't give them exclusivity or an infringement right the same way a patent does, but there are some good rejoinders to that Angie went through. On the other hand, you have to sort of temper that with a comparison to publication plans. If a journal or NIH or somebody's going to require this data to be published anyway, you sort of lose some of the value to it. If you're merely co-licensing data with a patent, maybe you don't need to push so hard on value of data. And maybe your institution just has a goal or a mission of wanting to get its technology out into the public. So you could sort of tilt the value accordingly. Then we talked about whether the extent to which you can have flexibility in expected consideration, the financial terms for a data license. There really isn't a going custom here. So I think everyone can rest assured no one will scoff at your institution for the paltry consideration you got out of a data license, because there just is no standard at all. And I don't know whether there ever will be one. Some of it depends on what the licensee wants. Sometimes they want to preserve upside by not having a sales-based royalty. Some want to defer costs by only having, sales-based milestones or royalties in the future. But the point is, you're really not limited by the same rules and rubric of patent licensing, so you can be flexible in how you license data from a financial standpoint. We spoke then about license terms, because data is not really an IP right. You have to treat it differently than you would licensing a patent. You really need to be very clear about what you want your licensee not to do with the data you give them, because there's no backup of infringement to claim if they do something they weren't supposed to. So anything that's required in the consent, don't re-identify patients, those sorts of things need to be stated in the agreement. And then because you're giving something that's a little bit closer to a tangible product or something that's not simply a right, like a patent right, it's a good idea to consider requiring your licensee to have additional insurance, cyber insurance, data breach, so maybe some more robust indemnification provisions, or even disclaimers about accuracy of the data or completeness of the data and so forth. Next slide. The key takeaways we had, Angie and I really wanted to just sort of reassure the listeners that data licensing, yes, it has some added procedures, but it can, and in many cases should be done for many good reasons. But one thing we really wanted to stress was that when you're looking at data that a licensee wants to license, and maybe it was generated without a mindset of future commercialization, your consent might not be ideal. I think it's important to start by assessing if you actually need a license or if some other alternative suffices. I know Corals has some clients, and Angie has had experience as well, just entering into fee-for-service or data analysis agreements or a long-term SRA, keep the data at the institution. And if there's just some information that the licensee needs to extract from the data or run an AI algorithm to be trained on the data, that could be done within the university sometimes. There could be faculty consulting arrangements, or even just give an IND or publish data. You may not have the same financial return, but that could be more consistent with informed consent than trying to immediately go down the road of anonymization and de-identification. And then lastly, we encourage the listeners to develop license terms now that are specific to data. Don't just try and use a patent license and try and avoid ad hoc revision of an agreement that already exists, because you won't think of everything. And so I think it's important for institutions to prepare for future data license arrangements instead of just reacting to them. And that was a summary. Angie, anything that you want to add?
No, that was great. Other than I'm seeing a shift, from should we license data to what if we don't license the data and the impact it can have on human health. So, I'm seeing an overall trend of increase on the need to have out licensing of data to primarily complement a patented technology, but also just to further impact on patient lives.
That's interesting. Shift that you've seen there, Angie, and I wonder if some of our attendees have been seeing that shift as well, which is perhaps also why this series has been so popular with people. Throughout the series, we did have a lot of questions in, particularly around GDPR. I think institutions are trying to figure out what to do with it, et cetera. And so we decided that it would be a good idea for us to go more in depth than we had before on GDPR, and David Pelequin kindly prepared some slides on this. So that will be the next section of this webinar. So David, take it away.
Thanks so much for that, Kirsten. And so I'm going to spend about 5 to 10 minutes talking about GDPR. This could be a whole 2-hour presentation in and of itself, but I'm going to try to hit some of the highlights and some of the pain points that I frequently see when I'm representing a US-based hospital or university that is trying to use personal data or pseudonymized data from the European Economic Area or the United Kingdom. If we go to our next slide, I think most people on this webinar are probably familiar, at least a little bit, with GDPR, which is the privacy law of the European Economic Area that took effect back on May 25th of 2018. The law applies directly in 30 countries. That's all 27 member states of the EU, and also 3 additional countries, Iceland, Liechtenstein, and Norway, which together with the EU make up the European Economic Area, which is why I always refer to EEA or European Economic Area instead of EU. Post-Brexit, the United Kingdom continues to apply the GDPR in what is known as the UK GDPR. Essentially, they copied and pasted most provisions of the GDPR from the EEA and put it in their national law. And one other thing to know about the GDPR is while it's one regulation for all of the EEA, there are certain parts of the law where the member states of the EEA are permitted to make derogations, make a different rule for their own country. And some of those derogations are for areas like scientific research, and so they can become relevant when you're working with parties in Europe. If we go to our next slide, this is just more of a refresher for everybody, a takeaway of where the GDPR applies. It applies in all of the blue and green countries, which are the EEA, and then in the United Kingdom, of course. Switzerland, which of course is an important country for biomedical research, doesn't apply the GDPR, but has its own national law. So you need to consider Swiss law separately if you're ever dealing with Swiss arrangements. If we go to our next slide, GDPR applies to personal data, which are defined very broadly as any information that relates to an identified or identifiable natural person. And that person is referred to as the data subject. People can be rendered identifiable by a variety of attributes, things like a name or an identification number, but also things like genetic information or economic or cultural attributes about that person may render them identifiable under GDPR, thus making their data personal data. If we go to our next slide, we'll see that personal data are defined broadly. As I mentioned, it applies throughout the economy. GDPR is not just about health data. So if you're dealing with information from Europe, the information of investigators in Europe or study staff located in Europe, that would also be personal data covered by GDPR. GDPR, however, does not apply to anonymized data. And the discussion of what is anonymized often comes front and center when you're dealing with arrangements involving Europeans. Last Friday, I was on a call with a US hospital and a university in Austria, and the whole discussion was about whether the data that were going to be sent from Austria to the US were anonymized or not. And part of the challenge here is that on the past webinars, we talked about HIPAA in detail and how HIPAA has these nice de-identification standards, either the safe harbor where you strip out baking identifiers, or expert determination method of the identification. GDPR doesn't have a list of identifiers you can remove to render data anonymized. Rather, anonymization is judged on a facts and circumstances basis. you have to take into account all the means reasonably likely to be used either by the controller of the data or by another person to identify the natural person. If somebody can re-identify the data, then those data are generally not considered anonymized. And that was actually the argument this Austrian university was making last Friday. They were saying, well, these data are so unique, even if we shed all codes from them, we might be able to identify them here in Austria. And so we think this is still personal data. Pseudonymized data, which are very important in research, which are sometimes called key-coded data, i.e. data in which you are going to strip off the names of an individual or other direct identifiers and replace them with a code. Those data are generally considered personal data under GDPR, although we have a recent case that's now pending before the Court of Justice of the European Union that may affect this interpretation. There was a lower court decision in April that held that data that were pseudonymized could be considered anonymized when held by a party that lacked access to the key needed to re-identify those data. And that was a really important view that was taken in that decision. That case is now on appeal because the European Data Protection Supervisor, who's in charge of interpreting GDPR in Europe, did not like that lower court decision. So the supervisor has appealed the decision to the Court of Justice of the European Union. And this might actually become the most important case, I think, for biomedical research in GDPR, because it would have major implications, I think, if one were able to take the position that a lot of pseudonymized data were actually anonymized. So stay tuned for more on that. One other thing I note is that GDPR doesn't apply to personal data of deceased individuals. That's different than HIPAA. We talked on our prior webinar about how HIPAA continues to apply for 50 years after somebody's death. Their PHI continues to be protected. GDPR says when somebody is deceased, their data are no longer personal data. But the caveat, of course, that I give here is that this is one area where, remember, I said the GDPR allows derogations. They allow different countries to take different positions in different areas. This is one of those areas. So certain member states of the European Economic Area have extended the protection of GDPR to deceased individuals. So you have to look at the country that you're dealing with when deciding whether decedent's information would be covered. If we go to our next slide, I think the biggest questions to ask if you're a US university or US academic medical center and you're dealing with data from Europe, the two questions that you should always ask yourself are, one, in this transaction, does GDPR apply directly to us as a US organization? And then the second question is, even if we determine that GDPR doesn't apply directly to us, and I'll talk in a second about how you make that determination, is the GDPR still going to be relevant because we have a cross-border transfer of personal data from the European Economic Area or UK to the US? Those are the two questions I would always ask at the outset. A lot of times Europeans don't think about these questions because for them, they're established in Europe, the GDPR is always applicable. But for a US institution, the jurisdictional question, as we say as lawyers, of does this law actually apply to us, I think is the first thing you should always ask. And so if we go to our next slide, in determining whether GDPR is going to apply directly to an entity outside of Europe, you have to think about the territorial scope of the law. And so this comes from Article 3 of GDPR. The law will apply if any one of three things listed on the slide is true. The first is that you're an organization that's established in the European Economic Area or the United Kingdom, and you're processing personal data in the context of an establishment. And the establishment would be like a physical location, like an office or branch. If your university has a campus in Italy, you process personal data and employees, let's say, on that campus in Italy, that would be personal data subject to GDPR. A lot of my US clients don't have establishments in Europe. So we're really focused on these second two prongs of when the GDPR can apply. So the middle box in our schematic talks about if an organization offers goods or services to individuals who are located in the European Economic Area or United Kingdom. And so this could be if you're offering, let's say, a mobile application that's targeted at people located in the European Economic Area or the United Kingdom, or if you're offering an investigational drug or device to those individuals. If you offer that good or service, you don't have to charge for it. If you're offering something to folks located in the European Economic Area or United Kingdom, you process their personal data in the context of offering that good or service, that would be subject to GDPR. Then lastly, there's this jurisdictional hook for organizations that monitor the behavior of people located in the European Economic Area or United Kingdom. And monitoring behavior is typically seen as things that are done online or through smart technologies, so tracking people's activities through cookies or pixels on a website or a mobile application that's collecting information over time from individuals, or looking at a stream of data from an electronic health record over time. Those could all be seen as monitoring the behavior of individuals. And lastly, what I note at the bottom of the slide is that the GDPR is agnostic as to the citizenship or residency of the data subject. And what I mean by that is when the law first took effect, we had a lot of clients here in the US who said, you know, our university, we have a lot of European nationals who work here at our university in the US. Are their data subject to GDPR? And generally they would not be if the people are employed here in the US at the university, even if they're a citizen of France or Sweden, their data would not be subject to GDPR merely because of that citizenship. But conversely, of course, if you have US academics, US students who go abroad for certain things like sabbaticals, and they are located in the European Economic Area or UK, you know, their data may become subject to GDPR because, again, this fact that they're a US citizen does not play into that analysis. So I always tell clients to start with this question: does the GDPR actually apply to you directly? And the reason that matters, if we go to our next slide, is that if the GDPR applies to you directly, then you have to consider the full suite of requirements that come along with the GDPR applying. And I don't have time to go through all of these directly or all of these in detail today, but if the GDPR applies to you directly because you're offering a good or service to people in Europe, if you're monitoring the behavior of people in Europe, you need to do an analysis of what's your basis for processing those data, especially if you're using health data, genetic data, race, ethnicity, those special categories of data that are subject to heightened protection. You have to think about how do you provide notice to data subjects, be it through an updated online privacy notice or a notice that's provided in a research consent. And you have to deal with a number of other things like data subject rights, establishing a record of processing, ensuring that any vendors that have access to the personal data are bound by appropriate contractual commitments, somewhat similar to how a covered entity under HIPAA has to bind its business associates to particular contractual commitments. There's certain security requirements that come into play. You may have an obligation to appoint an actual representative located in the European Economic Area or United Kingdom, and also to appoint a data protection officer. There's certain assessments known as data protection impact assessments you may have to carry out on certain types of higher risk processing. And you can be subject to the fines under GDPR, which I think many of us know can be up to 20 million euros or 4% of your annual turnover as an organization. But in many cases, when my US clients do the analysis of, are we subject directly to GDPR? They say, you know, actually in this transaction, we're not going to be subject directly to GDPR because maybe what we're receiving is a file of data collected from a medical record in Europe. And we're not offering a good or service to the individuals located in Europe. We're not monitoring their behavior. And so we could take the position we're outside the jurisdictional scope of the GDPR. Does that mean the law is irrelevant? No, it doesn't mean the law is irrelevant, but it means that what applies to our institution here in the US, the practical ramifications of getting the data from Europe may be less than they would be if we were directly subject to the territorial scope of the law. And so if we go to our next slide, what I'm going to close with is just a discussion of the cross-border transfer requirements in GDPR. And these are going to be relevant frequently, even if you determine we're not directly subject to GDPR here in the US in the context of our activity, but the European institution that's providing us data, like the example I had of the Austrian institution I was dealing with last week, that European institution is likely to say, well, we need some basis to legitimize the transfer of personal data from Europe to the United States. And note that a lot of times what people try to say is like, oh, well, we'll just store the data on a server in Europe and people sitting in the United States can just log into that server and view the data. And unfortunately, the guidance that we have on that issue from the European Data Protection Board and the UK Information Commissioner's Office is the mere viewing, the intent that the data be viewed by somebody in the US is seen as a transfer. So those somewhat geographical storage solutions won't always work. But the general rule under GDPR is that when data, personal data, are transferred from Europe or the United Kingdom to a country like the US that lacks adequate data protection legislation, you need to put in place a basis for that transfer. Now, that obligation to put in place the basis for transfer in an instance in which the US institution is not directly subject to GDPR, that obligation really in the first instance will fall on the European institution that you're dealing with, and they'll often drive the discussion on this. But if we go to our next slide, you'll see what the options are for legitimizing these transfers. I haven't listed every single option, but I've listed the ones that come up most frequently. The first option, which is actually a new one as of 2 months ago, as of July 2023, is something called the EU-US Data Privacy Framework, which is a program administered by the US Department of Commerce. And it allows US entities, US companies to self-certify that they adhere to certain data privacy standards within their organization. And then that company is treated as providing adequate data protection, and data can flow freely from the European Economic Area to that company here in the US. The UK is in the process of working on a similar framework with the US, though it's not finalized yet. One important caveat about this for listeners of this webinar is that the EU-US Data Privacy Framework in its current form is only available to for-profit organizations that are subject to FTC jurisdiction. And so a lot of nonprofit organizations are not going to be eligible for the EU-US Data Privacy Framework. And so you'd have to look for a different basis for transfer. This is something people in Europe do not understand very well. So a lot of times I'll ask my American clients, like, why aren't you subject? Why didn't you self-certify to the EU-US Data Privacy Framework? And then we have to explain, like, we're a nonprofit university, a nonprofit hospital, we're not eligible for it. But there are other mechanisms that are frequently used all the time to transfer data from Europe and the UK. And the one probably most frequently used are the standard contractual clauses, which are form agreements that the European Commission has put out. There's different versions for transfers from controllers to controllers and controllers to processors, and every one of the combinations of those two types of entities. And there's a separate set of clauses that are used in the UK that the UK government has put out, or kind of an addendum you can add to the European clauses to make them work for the UK. One thing to know about these is when you enter the clauses that allows data to flow from a European or UK entity to a US entity that has entered the clauses. You frequently have to do something called a data transfer impact assessment, which is essentially an assessment of what is the risk that the data may be compromised, for example, accessed by US national security services if the data are sent to the US. And you would do that impact assessment in coordination with the EU entity. A good thing about having this EU-US data privacy framework in place now is even if you're not relying on that for the transfer, you can take into account some of the protections that the US government has put in place for EU data. You can take into account those protections when doing your data transfer impact assessment. So the fact that there was this agreement reached between Europe and the US this summer can still be helpful even for my nonprofit clients that can't self-certify to the EU-US data privacy framework. If you can't use standard contractual clauses, which occasionally comes up for some of my public university clients that can't agree, for example, to be subject to foreign law in their agreements, which is a requirement of some of the standard contractual clauses, there's other derogations you can use to transfer data from Europe to the US. In some cases, you can get explicit consent of the data subject. That might work, for example, in an interventional study where you're actually getting consent from people. There's a narrow exception that allows transfers for certain public interest purposes. That's construed very narrowly. Even at the height of the COVID-19 pandemic, the European Data Protection Board said that public interest transfers, even for COVID-19 research, were limited, but it's something to consider. You can also transfer personal data to perform a contract with the data subject or a contract in the interest of the data subject in certain narrow circumstances. And then also there's something called vital interest, which is really about a life and death situation in which you're transferring data. Where I see that come up sometimes in the context of research is things like expanded access, compassionate use, where there's a vital need to provide an investigational drug or device to somebody and their data needs to be transferred to the US for that purpose. So that's the thing to consider, even when you're not directly subject to GDPR. Often European institutions are going to say, well, we need a basis to transfer the data to the US. And so these are the different bases that you can work through with those organizations. And so if we go to our next slide, that really concludes the prepared discussion I have of GDPR, but happy to take any further questions as we go into the Q&A session now.
Terrific. Thank you so much for that incredibly vast summary of GDPR and what the institutions need to be considering with regards to GDPR, with regards to data. A first question actually is related to GDPR, and I'm going to direct it to Angie. And it's more of a practical process question at academic institutions. Who's involved in the GDPR compliance discussions at your university? So who's actually like overseeing this and making sure that guidelines are followed?
It's funny you ask this question. We are officially, Broad is launching and establishing up what we refer to as a platform transactions position. This person will also have GDPR expertise, HIPAA, BAA. I work with both David and Steve on these topics, and they've been a lot to tackle. I joined Broad in November of 2022, and the ecosystem of the Broad is affiliated with 5 different hospitals, all having different regulations who are then collaborating overseas. So it just makes it compoundingly complex, and to try to train a team of 8 to 10 negotiators on GDPR is just insurmountable. So we decided to have one point of contact, an expert within, still relying on outside counsel because these are highly complex. And as David said, subject to fines. And I'm increasingly getting the question, are you GDPR compliant? That's a hairy question in its own, and how to navigate that. And I think that's in part due to some of these newly adopted iterations of GDPR. But overall, I think people are getting the acronym correct now. I think everyone, can say GDPR pretty quickly. Now it's like they know it's dangerous enough to kind of freeze, and it's our job to get that research out and moving. And so, yeah, we're making a single point of contact. I can't highly, recommend that enough, because these questions come up across several different verticals within our institution.
Great. John, how about at Vanderbilt?
At Vanderbilt, it is an interface between my office, the Office of Contracts Management under the Sponsored Programs umbrella, our legal office, and we have an international privacy office that was recently created. And this is what they live and breathe all day long, GDPR and other institutions. And when something comes into us electronically, it just automatically gets instantly routed to them. So that they're jumping on it, and they utilize outside counsel, they utilize internal resources, but we do have it's really 2.5 people where that is their whole life. Because just like Angie said, you've got to have somebody who this is their total focus. You can't spread it in bits and pieces all over the place.
And David, you're working with a lot of these institutions. Is there something kind of general that you're seeing in this area, as far as the GDPR compliance, and who's working on that?
Yeah, I think increasingly, as here in the US, we have a number of state privacy laws that are coming online as well. Increasingly, institutions have a privacy office that have 1 or more dedicated professionals. I think traditionally, HIPAA covered entities had their HIPAA privacy officer, and sometimes in those types of entities, the HIPAA privacy officer will also advise on GDPR. And then my university clients increasingly have a team of folks who are focused on data privacy issues.
Great. Well, if we have other GDPR questions come in, I will ask them of you guys, but we're going to move on to some other areas right now. One of the questions that was asked ahead of time by folks was actually wanting to discuss DUAs that have data security terms and end user license agreements, just to have a discussion around that area. David, we were going to have you start that off and then move to Nick on that as well.
Yeah, of course. And I think, people use the term data use agreement or DUA in a few different ways. So I think first you have to figure out, is it being used, is the term used in a regulatory sense? Because remember, we talked on our last webinar about HIPAA has this concept of limited data sets, that is PHI, from which you shed most identifiers, in which case you're going to need a data use agreement that complies with HIPAA's standards for a DUA, which includes that there be appropriate safeguards to prevent use or disclosure of information other than is provided in the DUA. Oftentimes, though, when people are talking about data use agreements, they're using the term more generically to refer to any type of agreement that puts certain terms and conditions around the use of data. And so the terms are more negotiable when it's not a HIPAA limited data set, because you're not confined to the standards that are put in HIPAA. With respect to data security terms, when institutions have specific terms they're attaching to those DUAs, I frequently recommend that a client's IT security function become involved in the review, and that they look at those standards and ensure that the recipient institution can actually meet those standards. It has processes in place to adhere to those standards. When it comes to end user license agreements, frequently like a EULA is something I would associate with a mobile application or some type of digital tool that's provided. So if you're receiving the data through a mobile application or digital tool that requires agreement to an end user license agreement, it would be good to review that to understand what the terms of that agreement are and whether any of them might conflict with other terms you have in place in your data use agreement, let's say, for use of the data. That's generally how I would approach these topics.
Nick, you want to comment for Chicago, what you're seeing?
Sure. So yeah, I can speak to David, if we're just talking about sort of the genericized use of the term data use agreement, whenever I've been involved in projects where we are sharing data with an outside entity or a third entity, the data use agreement that, first of all, we would require a data use agreement of some type. And there would, if the data is actually going to leave our facility and is going to be, housed with the third party, then our data use agreement would require a description of the security that's going to be put into place. Someone from our information security office or another domain expert will likely be reviewing that to ensure that everybody over here is happy with that. I would also say that it generally doesn't matter if the data that we're sharing has been de-identified or not. We occasionally will get someone will say, well, but you're going to de-identify the data. So, if we store it on, a thumb drive over in some of our offices over here, who cares? And they're like, well, no, even if we're the ones doing the de-identification, we also want to know how you're going to be storing it, how you're controlling access. And if there, has to be a discussion between technical teams, then we would, certainly set that up. But that's usually a provision in any of the agreements that I've seen. And although I don't know that I would consider it to be like a EULA, certainly our data use agreements will often contain descriptions of how we are allowing the data to be used, usually within the context of a particular research project. We're giving you this data for the following specific purposes or specific aims of your project. And so the expectation is that, not only is that what it's going to be used for, but generally that's all it's going to be used for. So there is oftentimes a provision in there which states that, you're using it for this and nothing else. You're absolutely not reselling it or sharing it, with anybody else that we're not aware of. And that in general, the reason why this agreement exists is to support this particular say research project. It's usually not to sign over the data for that third party to use for whatever purpose they might want. There may be a provision that states if you want to do that, you have to come back to us and we're going to review what you want to do. And, there's certainly we might think that's also a great idea and we'll approve that. But it's usually not open-ended in that once we've, made the data available and you're storing it in a way that we feel is secure, then that's it. And then even if the data is going to be like cloud hosted, for example, then we would still need to review the security requirements there. And if we're keeping the data on site, but we're allowing you to access it, so that's one way of us covering the security provisions internally, we would still want to understand how you're planning to access it, right? So like from your remote site, who are you going to grant access? How is the the data going to be controlled in that regard?
Angie, you look like you might have had a comment there as well.
We just noting, like nodding so much to what Nick was saying, because we just recently added to our checklist for sponsored projects to ask this question early and demand to see the DUA. Got to an end of a big agreement. Researcher was confident that they would be able to use the data for the intended purpose because they've been permitted to do it before, and why not again? And then when we looked at it closely, it delayed everything for a few months, which didn't make anyone happy. And so it's a question to get started. I mean, of course, everyone wants to start everything sooner in the process, but this is one that we've learned to ask up front.
Good anecdotal story there about processes and what you should be preparing for ahead of time. Angie, thanks. Steve, next question to you. Does clinical development involve an element of data licensing, or are they two distinct arrangements?
I think the answer would have been different 10 or 12 years ago. And I think now they're becoming sort of parallel operations. So I can remember the first time I looked at a sponsored research agreement, however long ago, and it was very common for universities to say, oh, the sponsor, you will have the right to use all of the data that comes out of this research, or you will own the final results. And it was just this very sort of like hand wavy language. And then we get to the point in time years later where we're negotiating a license to to a patent that came out of that research, and we say, oh, well, we'll add in this concept of licensed technology. And the licensee says, no, we already have all that. We don't need it. And so now I think it's sort of flipped, where sponsored research offices at our clients and the tech transfer offices have to negotiate the license and the sponsored research agreement at the same time, which presents some challenges. But you really can't just categorically say in many instances that a research sponsor has the right to use data coming out of the research for any purpose, which is frustrating to them because they think, well, I'm paying for it, I should own it. But you have to have some sort of a license in place. And as soon as you have a license to data, then that begets a license to future patents. And it can be a really thorny issue for our clients to try and negotiate things that don't exist yet from a financial standpoint, while also ensuring there's a license today during clinical development to satisfy use restrictions. So I think the two are certainly merging.
Great. Angie, we just had a question, and I'm going to ask it of you first, but others can answer it as well. Does your research contracting office ever handle DOAs for non-clinical or preclinical collaborations, for example, sending data to a public entity for their quality improvement projects?
Not as much. I would say it's definitely more of a focus on patient-derived data increasingly, but yeah, I wouldn't say, yeah.
Okay, great. Anyone else have a comment on that, or?
It would be the same answer from me, although in VUMC's world, it's actually our supply chain office that handles the agreements where we're sending like quality data and benchmarking data to, because we're looking at that as a purchase service, even if it's like a membership agreement or some such thing.
Great, thank you both. Another kind of practical and process question. This person would like to know what IRB and CORI review is required to move forward with a patient data license at your institution. And Angie, I'll start with you on that.
Great. Yeah. So I was formerly at UCLA for 5 years, and they had quite a robust process because they're a big campus and there are different perspectives that need to be considered when doing a single transaction. I think with a patent license, it's a single intangible right with data. And then you layer on top of it patient-derived data, you do have conflict of interest, and there's a conflict of interest committee. And then you have, is someone valuing it correctly? And how does the university itself think about out-licensing data and this type of data? And so it put together a very formalized process that it had to go through and get initialed by all of the different constituents. At the Broad, we're a little bit tighter, smaller, so we're more nimble and able to kind of bring in the proper individuals, but it is the same sort of, we have to bring all of the voices in and all be aligned on what, the interest of the institution is. It's so now that I've been at 3 different academic institutions, it's so institution specific. What is the lens through which Broad versus UCLA versus my prior to that, University of Wisconsin-Madison, what is their perspective? And then you have to work through that. So it's not, you can't really lift one university's perspective in processes and expect them to fit within another institution, unfortunately. So they're kind of homegrown, I have found.
I think that's really important for those who aren't at the universities who are listening to understand as well. Like, it is not like just because something worked for you at one process at one university doesn't mean you're necessarily going to follow the same process at another university. So David, I know that you were potentially going to comment on this question as well, perhaps because you work with so many institutions.
I completely agree with Angie that a lot of it's going to be institution specific and driven by the institution's policy. I do think sometimes it's helpful to take a step back though and think like, as a regulatory matter, do we need IRB involvement, IRB review of a specific scenario? And when we're talking about data, that's often going to turn on whether the institution is itself engaged in research, which is a term of art, of course, under the federal research regs known as the Common Rule. And there's guidance from the Office for Human Research Protections on this point. But when we're talking about patient data, if one institution is merely licensing data to a second institution, and the second institution is actually the one that's doing all of the analysis, all of what we might consider the research, in that case, the first institution is a regulatory matter. It may not actually need IRB review for that disclosure of data, and that's pretty clear in the OHRP guidance. As a matter of institutional policy, there might be a role for the IRB of the first institution to be involved, but as a regulatory matter, that might actually not be needed. Of course, if we're dealing with PHI and we have a HIPAA-covered entity involved, you have to think about, is there a pathway for disclosure under HIPAA? And if we're the recipient of data, then thinking about whether IRB review is required, again, from a regulatory standpoint, what we'd be thinking about is things like, are the subjects, the data subjects here, are they identifiable by the investigator, or are we going to be submitting any data to FDA from the analysis that we're conducting? That may be a trigger for IRB review as a regulatory matter, in addition to institutional policy. With respect to conflict of interest, I just add that, like Angie said, a lot of that's going to determine your institution's conflict of interest policy, but I do increasingly see attention to, especially like institutional conflicts of interest, if there's patient data that might be licensed to an entity in which the institution that's licensing the data has an equity interest, for example, that may raise a conflict of interest, an institutional conflict that would be evaluated by a conflict of interest committee within the institution before the transaction goes forward. And so it's important to be mindful of those institutional conflict policies at the outset of these types of licensing activities.
And everything that he just said, again, John and Mike, like, you need to have an expert because it's a lot.
So next question, and this is kind of a broader like thinking question, not a process question, but has anyone considered or devised a mechanism to flowing licensing income back to the patients? And Steve, I was going to have you comment on this one first.
Yeah, this was an interesting question, and Kirsten kind of clued us into this ahead of time. So I asked around the firm, and none of us can think of a client that has formalized a policy where they'll try and flow income back to patients. That's not to say whoever asked this question was the first person to have this idea. We've been asked that question. But I think once people have gone down the road of thinking about what that would necessitate, they've decided not to do that. But I will say there are a few Corals clients who flow income back to researchers who maybe weren't like inventors of a patent, but helped generate data and are sort of key contributors to a research that generated data that was licensed. So they'll share revenue back with them, which also creates its own hiccups, but we've never seen it with a patient actually put into practice.
Did you want to comment on this one as well?
Yeah, sure. My experience is similar here with Steve's, that I have not seen this in an institution give any type of profit or money back to the research participants or individuals. In fact, I mean, under the Common Rule, you have to tell research subjects, for example, if there's any commercial profit that might be derived from their biospecimens, for example, and whether they would share in that profit. And uniformly, I see consent forms telling subjects that they're not going to share in any type of commercial profit. I also think that if you're a medical center or any type of entity that's billing federal healthcare programs like Medicare or Medicaid, if you were to engage in that type of practice, you'd have to look at it closely from a fraud and abuse perspective under the civil monetary penalties, beneficiary inducement provisions, or the anti-kickback statute, because that would be another angle to consider if any type of remuneration was going to be provided to patients who might use your services.
Thanks, David. Another question just came in. I'm actually not sure if any of you can answer this. How are research foundations handling the revenue sharing in the US? Does anyone have an inkling on this? And I know none of you are at foundations. Steve?
Some will share a lesser percentage. I think the question is, you know, how do you allocate revenue to data generators as opposed to inventors or something under a license. You really have to have a policy in place. And then the trouble is you'll have an institutional policy that says 30% of revenue goes to inventors. You can't take away some of that and give it to a data generator because the inventors never agreed to that. So foundations are kind of thinking, well, we actually have to take data sharing out of our own share of revenue so as not to hurt the inventors, or we really need to have just a policy where everyone understands there's a bucket that is unique to inventors and data generators together. So it's a tricky issue that's really intertwined with IP policies.
Nice. All right. Someone else asked about the differences in the models of how licensing works for data relating to pharma versus medical devices versus diagnostics versus digital health. Angie, could you talk a little bit about that area?
Sure. So I sat back today, we were interviewing for that position I mentioned, and thinking about just how licensing is changing generally. And it seems data and speed to market is, data is becoming increasingly important to the patent asset. It'll be interesting to see if it becomes of equal, if not greater importance in the long run, just because technology, clinical trials might be over time become shorter and therefore less expensive and less of a period to protect the asset going through the regulatory process. But, what I'm seeing is an increased weight on data and even maybe a gating item as to whether they'll take the patent license. And then in particular, when that data is based on individuals that are not, patient populations not easily accessed. So, just I would say generally when I zero out and I think about the last 10 years, I'm suddenly seeing, just like ChatGPT, like a sudden uptick in the importance and focus on the data and whether they can get access to that. So we're clearing that first in all of our licenses, making sure we can correctly define, to Steve's point, what is it that we're licensing with precision so that there's no surprises after execution when we deliver the asset. What is it that we're describing in the appendix? With patents, again, it's very easy. You just identify the patent application numbers, and you might have to worry about some divisionals with data. You have to think about cutting off improvements, how much detail when you say that you're going to give these particular records. Are you appending, when it's not feasible, all of the records to the license agreement? Probably not. So how do you ensure both sides understand the value of what they're receiving? I think that there's just more time required, more transparent discussions needed at the front end of a license negotiation when data is involved. And often, again, data is becoming increasingly a gating item to then they want to make sure they can get access before they continue.
David, did you want to comment on this as well?
Yeah, I think one thing to think about when you're working with pharmaceutical or medical device manufacturers is how they intend to use the data. And if it's patient data, are they going to be using any of those data in a submission for a marketing or research application with the FDA? Because if they are, then some of the requirements in FDA regulations about IRB review of activities or informed consent of subjects becomes relevant. Just last week, FDA released an important guidance on real-world evidence used for drug product development. And that guidance has some clarifications on when are certain real-world evidence activities subject to IRB oversight, when do they require informed consent of the subject. And so that's something to think about in this area. With respect to medical devices, a lot of times along with data, certain images might be transferred. And under the FDA regulations on medical devices, those images, even if de-identified, might be treated as a human specimen that's considered a human subject to IRB oversight. If data derived from those images or specimens are then shared, submitted to FDA in support of some type of application. So that's something important to keep in mind, I think, from a regulatory standpoint, whenever you're dealing with a pharmaceutical or medical device manufacturer, or increasingly digital health companies that are producing technologies that are regulated under FDA software as a medical device framework.
Thanks, David. We are approaching the top of the hour. I know that some people are going to have to drop off then. We have a few more questions left. We'll try to get through all of these before we end. So for those of you who can stay on, that's great. Otherwise, this is being recorded. You can watch the rest of it later. We do have a survey that was, the link was put into the chat. It'll also pop up as you leave. We really do appreciate the responses to those surveys. They do help us with future webinars that we may put on as well that may be of interest to all of you. So I'm going to ask these remaining questions. We'll get through it probably in the next 5 to 10 minutes. Thanks for those of you who can stay on with us. Steve, did you have another thing that you wanted to add on to that last question? I apologize. No. Okay. All right, then I think this next question goes to you, David, from one of our current attendees. Is transferring data associated with samples from US to a EU organization that may redistribute to researchers and possibly for profit for the research, does GDPR apply to the providing US institution in that particular case?
Yeah, so this is a great question. It's a little bit like a law school exam question. So if we have a US-based entity and they're transferring data and samples to an EU organization, that activity in and of itself wouldn't bring the US institution within scope for GDPR, because they're not, if we think about that schematic I showed and when GDPR applies, the US institution, I'm assuming, was not established in Europe. They're not offering a good or service to individuals in the European Economic Area or monitoring the behavior of individuals in the European Economic Area or the United Kingdom, for that matter, when they transfer samples from the US to the EU. Now, in the hands of the EU organization, those data, assuming they're personal data, would be subject to GDPR because the EU organization is going to be processing them in the context of its establishment. And if the EU organization then distributes those data and their personal data to other researchers, let's say researchers in the US or other countries outside of Europe, then those transfer restrictions that I had mentioned in GDPR would become relevant. This actually frequently arises for clients of mine in arrangements in which a US institution or a US biotech is doing a research study or a clinical trial here in the US. They collect samples in the US. The whole study is happening in the US, but they decide they want to engage a laboratory in Europe to be the central lab for that research activity. The European lab will generate data from the samples and then transfer the data back to the US, and that will be a restricted transfer under GDPR, and often standard contractual clauses will be needed for that transfer. That often catches my US clients by surprise because they're saying, well, everybody lives in the US in the study. The whole study is in the US. But by transferring the samples to Europe, they've created a restricted transfer when those data come back to the US. But even in that type of circumstance, if the only activity that has a nexus to Europe is the lab processing the samples, you know, that US university or company could frequently take the position that it's not itself directly subject to GDPR, but it would have to consider the transfer rules under the GDPR.
Great. Thank you so much for that very clear explanation, David. Angie, are you seeing patient data licensing practices affect other types of data licensing that the university may conduct?
Yeah, I'm not sure I entirely followed this question. Is it saying that is it slowing it down?
I think actually they're wondering if some of the processes that's happening for patient data licenses or some of the terms that are associated with this patient data licenses are being moved to things that are non-patient data.
Yeah. Okay. Yeah. So we put together a diagram that asks those questions, and quickly, to a lot of David's points of, you may be exempt if this, and you may be exempt if that. We are pretty quick about running it through that triaging to make sure, because researchers are always, a lot of pressure to get things moving, that we're pretty quick at like funneling those out and handling them with the least onerous terms as possible. So no, I'm not seeing that, but it has become necessary to create a triage so that everything isn't overanalyzed. We forget everything that's like, again, in David's head about, oh, you could have an exemption here or there. And just the research and what they're conducting matters. So yeah, I guess I'm not seeing a big impact, but that's only because of the process that we had to put in place.
Mm-hmm. Steve, did you want to comment on that?
I have seen it. So I think there are tech transfer offices that are attuned to HIPAA, and they'll think about patient data and they know to sort of ask questions, and it needs to be vetted and consent, et cetera. But I think that has caused them to start asking questions about other data sets as well. And especially data sets that come from like colleges of engineering, where you wouldn't think about HIPAA applies, but maybe a biometric law applies in things like scanning human behavior for AI purposes. They start to ask questions and say, you know, wait a minute, is this personal data or private? And I think then they regret asking Quarles that question, because it's one of the worst parts of this job is a deal is mostly negotiated, and then we say, well, you can't do that because you didn't ask these people consent, because a computer science professor never thought about that at the time.
Great. Thank you so much, Steve. All right. Sorry, there's one other question. So can consent forms or waivers circumvent HIPAA or GDPR requirements? Nick, maybe I go to this for you first and then David.
Yeah, I don't know that you can circumvent the requirements necessarily when it comes to HIPAA, but if, for example, like within your consent form, assuming that your IRB has approved it, you explicitly state how the data is going to be used, and that might include the transfer to a third party for other types of research. You're not really circumventing it. You're operating, under HIPAA as it's written, and in theory that can be allowed. Now, whether or not your IRB agrees with what you would like the patient to consent to is perhaps a separate issue. And so that may be something you have to work out specifically with your IRB and what they are comfortable doing and what they're not comfortable doing. But, technically, if it's explicitly stated in the consent form and your IRB has approved that form as written, and the patient or the participant, consents to have their data used in that way, then, that should be okay. It's just, I think, more from an institutional standpoint, as we've talked about here, whether or not what it is that you want to do even has a chance of getting past your IRB, because some IRBs might be okay with certain things and other IRBs may not. So.
Thanks, Nick. David, did you want to comment on that one as well, since it also had GDPR?
I agree with what Nick has said. I mean, it's really figuring out what is your pathway under HIPAA, under the common rule, under whatever regulations apply to you, to make sure that the consent or authorization in the case of HIPAA that you're using complies with those requirements. Under GDPR, consent is one basis for processing personal data, and there are certain requirements for consent under GDPR. Also under GDPR, there's certain elements of notice you have to give people about how their data are processed. And so it's not so much that consent would be a way of circumventing GDPR requirements, but the consent you're using might allow you to deliver notice to patients. It might allow you to establish a basis for processing, or in some cases, even a basis to transfer data out of the EU. So it is something to look at carefully under GDPR in addition to HIPAA and the common rule.
Thanks. Steve, did you want to comment as well, or no? Okay, so I'm going to move on to the last question to all of you. With the context that the reason that we created this webinar series was actually academic institutions coming to us and coming together and saying, hey, we're all grappling with this area. We're figuring it out as we're going along here. We're having experts weigh in on this, but wouldn't it be nice if actually we could learn from each other what it is that we can do? What is the data? What can we do with the data? How do we license the data? And so that was the development of this particular webinar series. But obviously, there are still outstanding questions out there. And so I'd like for each of you to answer, what are the major areas that you're grappling with that still need to be solved for? And how do you think that those solutions may come about? And John, if you don't mind, I would start with you.
Well, I mean, I think we've really been hitting on the ones that I see all the time. I mean, I think our biggest challenges are the international landscape that's been discussed pretty thoroughly today. Thank you so much for some super clear explanations that I'm going to forward to my colleagues. But also the weird, varied landscape of state data privacy things that we're now having to, I mean, the example that was given earlier of like a US entity transferring something to Europe to be analyzed, transferring back to the US, we've had exactly that, but compounded by the fact that the data had, there were rights to the data from 6 different US states that all had different regulations governing what we could do with it, and it was a mess. But we got there, but it was a challenge. So it's like the immense variability that comes with both the international scene and the various state laws is probably our biggest ongoing challenge.
Thanks, John. Nick, do you want to go next?
Sure. I'd say for me, and I'm sure anybody who works at a university would say roughly the same thing, is biggest challenge that we have faced in the past and continue to face is probably trying to get institutional resources to address these types of issues, particularly as the landscape continues to change, right? So I know someone had asked about the NIH data sharing stuff, earlier, and so that it didn't throw people for a loop, but we had to kind of rethink, things about, okay, well, what if we have to start making lots of data available in public repositories? Do we have the resources and the horsepower to be able to do that at various types of scale, or do we want to come up with a different way to try to host it? And a lot of these times we tend to just sort of learn this stuff like a trial by fire. So, with the principles that in the paper that I referred to earlier were written by our data stewardship committee here, who basically, drafted the principles at doing a number of different types of, review, both from in a legal and regulatory perspective, but also from an ethical perspective. And then those are also the teams that are tasked with reviewing all of the requests for data that come through, and we're not getting fewer requests, we're only getting more requests. And so that, requires additional person power and resources to try to, both from a legal perspective and from an ethical perspective, to try to get all that stuff to happen. And with the advent of AI, we're only going to see more of those, because we get requests from people that we've never heard of before saying, I've got this cool idea and I just want to dump everything into ChatGPT. And I have to tell them, no, you can't do that, but let's try to figure out a way we can make this work for you. And there doesn't tend to be a requisite increase in hiring people or retaining outside experts to try to solve all of these issues. So that's where I would say that I would imagine most other academic medical centers are in a similar boat. We all want to try to facilitate all of these things, but it's only getting more complicated, and we're trying to do it with the same amount of resources. So,
yeah, it took a lot of advocacy, I would say. I think getting all the noise to come to one spot and then showing the amount of noise that's present. I think when it's so spread out, it can seem like a headache, but they're like, how big of a problem is it really? But when you think of all the lost time and resources, we probably have at least, X number of people time that if we just hired somebody who really knew what they were doing, and we'd have less liability. So trying to make that case, outline the time, so I think that came to mind, training and templates. I wish we had, a go-to templates. I think there's groups trying. I know Autumn talked about this just last week among a group of us, and thinking gee, we could really use a UBMTA for this, where there's some guardrails set up and force universities to think about, at least generally to the extent we can, think about the same things, and to lower that amount of time that's needed because we're to review these agreements, because they're all trying to say a lot of the same things. If we knew we just could focus in on certain areas because we know the rest of it is okay, that would save, I think, negotiators all around. Because I'm finding that you need both sides to be highly educated on the points to be successful. And we're just at the early stages of that, I think.
Thanks, Nick. Thanks, Angie. Steve?
Yeah, I'd agree with the last thing Angie said. And I would focus, I think, on the very beginning and the very end of the data licensing process, from consent and then license templates. So, there's a lot of aspects of privacy law that everybody's talked about that are just going to be a problem that you have to think about, or not a problem, but an issue you think about no matter what. But the questions that I wish I could answer better for clients are when they show me a consent form that says, well, the patient agreed this could be used for research. Does that include product development by a company? There isn't an answer to that. And I think, if tech transfer offices and whomever is generating patient consent forms, if it's your IRB or the general counsel's office, talk a little bit, and there's a few base hits that I think can be made in consents in the beginning. It's not going to solve every problem, but it's heartbreaking for me to tell my clients there is no answer to that question. You know, you just have to decide if it's a risk profile you can accept. And then on the other end, you know, clients that kind of struggle with, well, I have a patent license template and I'm trying to hear voices from all over the university about what needs to get put in here because of data, and you know, you can wind up with an agreement that is just overstuffed with thoughts, and it frustrates licensees and universities. So I think at least the things you could control, the very beginning and the very end of the data licensing process.
Fantastic. David.
I completely agree with what Steve has said about the consent process and thinking broadly about what are possible future uses of the data. And thinking about what the risk profile of the organization is and making those decisions. I think also what John had said on the state laws really resonated with me, because we do now have this panoply of state laws on data privacy that are emerging. A lot of them have exceptions for research activities, for information covered by HIPAA, for nonprofit organizations, but the challenge is those exceptions vary from state to state, and it requires a real careful analysis for each activity, which can sometimes slow things down or be burdensome on institutions. And then lastly, I think one area that even since I presented my initial webinar back in January that has really exploded for me and a lot of my clients is just generative AI and the use of patient data in generative AI technologies for training purposes, or even using those tools, for example, in patient care. And I think that's something that people are really grappling with. How do these rules that we've established, how do they apply in the AI environment? And a lot of times the same rules you have to apply, like from a HIPAA standpoint of considering, okay, is this a use of PHI? Is it going to a third party? Are they our business associate? Is this a research activity? But you now have to teach the folks within an institution who are working on these AI technologies how they apply those rules. And I think that's going to be a major challenge for a lot of our clients going forward.
Perfect. Thank you so much, David, Steve, Angie, Nick, John. I feel like based on everything you just said, we should probably be having some more webinars in the future to talk about each one of these areas and how people are actually handling each of those areas as they're coming up. I know that, just to relay again, I know that the audience has just been incredibly appreciative of you bringing your expertise to an area where there's been a lot of confusion, not always the established best practices yet, and you've helped illuminate issues, but also solutions for them in these particular areas. So thank you all so much. Thank you also to Gavin and to Robin and Neela, who also participated on some of the webinars in this series, and the group of institutions that helped us put this entire webinar series together. So thank you so much for being a part of this. Thank you to our audience for coming back each time and asking all these questions that our panelists could answer for this. So we really appreciate everyone's time that they put into this, and I hope that everyone can find this useful for the future and everyone enjoy the rest of their day. Thanks again, everyone. Bye-bye.